Hi Facebook family, my name is Caroline Hernandez and of Hernandez Law Office, and I'm here today to talk to you about 39 bankruptcy myths that exist about bankruptcy. This is going to be a series that will be explaining bankruptcy, and there's actually 40, but really in fact 39, and I'll explain that during the course of the series. Each week we'll be addressing two myths that I have selected between the myths that I commonly hear when I'm speaking with clients that they bring to my attention. In large part, I think a lot of the confusion and maybe the myths that exist happen in fact because there was an overhaul in 2005 of the bankruptcy laws by Congress. So many people remember what they could do or they did before when they filed for bankruptcy prior to 2005. One of the changes that existed is prior to 2005, you really got to make a choice whether you wanted to file for a 7 or a 13. Wherein now when clients tell me what kind of bankruptcy they want to file, my first thing is to assess what type of bankruptcy they can file. And one of the things that allows me to help them make that decision as to what bankruptcy they're actually going to be eligible for is a means test that was created by Congress to determine how much disposable income a person had based on where they live and what their income was, and what Congress felt was income that was left over and disposable for them to pay their creditors back. So the idea is that if you're under these exemptions and these guidelines and you fit within the means test, that you're either going to file for a Chapter 7 and everything will be discharged, or even in the event that you don't qualify for a Chapter 7, that you can do a 13, and in that plan you'll be making a repayment to your creditor of some percentage, and you'll still be able to have some form of bankruptcy law protection. So one of the common myths that I hear from clients is, well, I can't file for bankruptcy now because everything has changed, and if I file for bankruptcy, I'm going to lose everything. So people will commonly come in and will talk to me about what they can do short of that. They'll be, sued in collections or have wage garnishments, and they're not even looking for a bankruptcy. Most people, sometimes they do, sometimes they don't, but they're really concerned about not doing a Chapter 7 because they're going to lose everything. And by losing everything, most commonly what I understand that to mean is they're going to lose their house, they're going to lose their car, they're not going to be able to have a bank account or any kind of savings, they can't have any kind of pension or 401k. So the guidelines that Congress created after 2005 do allow for exemptions, and most of the time when I meet with people, it is very common that they don't have assets as they're defined by Congress in bankruptcy law these days, so they are permitted to have a discharge. So most people that come in typically don't have very much equity, little to no equity, or sometimes they're even upside down, but they do want to keep their home, or they still owe their car, and even if they have a car that's paid off or multiple cars that are paid off, they don't have a lot of equity in these vehicles. And with regards to savings, one of the things I commonly tell people is, I promise you will be able to have a bank account if you file for bankruptcy, either 7 or 13. So exemptions exist, and as long as your belongings and assets fall within those guidelines that are under the exemptions, then you can file for a Chapter 7 and receive a full discharge of debts that are eligible. So more than anything, we assess what kind of disposable income it looks as though you have. If you're in a 7, then we commonly look at what you can keep and how it is you can keep it. It is very, very common and not very difficult to be eligible for a Chapter 7. And part of that is looking carefully at what your assets are, how their value is measured, and making sure that you're allowed the protections afforded to the bankruptcy to keep belongings and still be able to discharge debts, because you can demonstrate that you don't have disposable income to pay your debts. Another common thing that people are concerned about is medical debts. One of the good things that happened when they did the overhaul for bankruptcy laws in 2005 is that Congress really took into account the fact, after much research by Congress and different committees that looked over the bankruptcy law reform, is that they found that one of the things that commonly contributed to people having to file for bankruptcy was having unexpected illness and medical expenses that weren't covered by insurance and resulted in job loss or decreased income for a certain period of time. So one of the things that they did in order to be considerate of that and acknowledge that that was something that led people to need to seek bankruptcy law protection and file for Chapter 7 or Chapter 13 was this means test that I've mentioned. Things like Social Security, disability, income, and payouts like workers' compensation and so forth, are looked at differently, and they're assessed differently, and they're not treated as income per se in some instances, to a certain degree, by the means test. So in many ways, a lot of people that are in debt because of medical expenses can find protection in a discharge through a Chapter 7 or in a repayment plan that is made through a Chapter 13. So one of the things that we need to consider, be mindful of, is I can't say outright that all debts are going to be discharged. So one of the things that we need to consider is that Illinois has something that's known as the Illinois Family Expense Act. And what that law considers is that any expenses that are made towards the welfare of the family are the husband and spouse are both considered responsible for. So one of the things that means, and you have to be mindful for when we're looking at medical debt, is that if you are married, and when we're looking at your debts or your spouse's debts or the debts of your minor children, we need to consider who's going to have liability for those debts and if they're going to be covered by a bankruptcy protection. Most times we can consider whether the husband or the wife or both have to file for bankruptcy, and in particular that when we consider medical debts, that's when we have to look at things carefully, because based on the Illinois Family Expense Act, you can be responsible for your spouse's medical debts as well as your minor children's medical debts. So in those instances, we have to look and see if it's an instance where you can file for Chapter 7 or 13 as an individual, or if you're filing as a married couple. So those are things that we consider, but more than anything, we do know that Chapter 7 bankruptcy and 13 does afford protection for medical debts, and it either allows you a way to discharge the debt completely or allow for repayment in a 13 plan. So I look forward to meeting with you and discussing more of the particulars. But in general, what I can tell you is that it is very unlikely that if you are eligible for a Chapter 7 that you will not be able to reaffirm your home and continue to pay for it, or reaffirm your vehicles and keep the vehicles that you already have that are paid. You will be able to have a bank account, and it's to date, and this has just been my personal experience, I've never seen a client of mine being eligible for a Chapter 7 based on how much they have in their pension. So you are allowed to have your pension or your 401k, and that income, that asset, is not typically does not disqualify you for a Chapter 7. If you're in a higher income bracket, those are things to look at, but there's still ways to be afforded bankruptcy law protection. And with regards to your medical debt, again, that's where you really want to speak with a seasoned bankruptcy attorney, because somebody that isn't aware of the nuances of the Illinois Family Expense Act isn't going to realize that if only one of the members of a marriage files, that the debts can be that the spouse that did not file for Chapter 7 protection can be held responsible for the debts not only of their spouse but also of their minor children. So I look forward to answering questions if you have them in more detail, but overall, despite the changes that came to bankruptcy law in 2005, many people don't lose everything. They are allowed to keep their belongings, and they can discharge their medical debts in a Chapter 7 bankruptcy and find a way to pay back those debts if they're not eligible for a Chapter 7. So thank you very much. Check in next week when I will be addressing another 2 bankruptcy myths, and I will be following this with debunking these bankruptcy myths in Spanish next. So join me if you would like to hear this presentation in Spanish. Thank you. Bye.